I think we're up and running. Let's check. Testing 1 2 3. Testing 1 2 3. 3 2 1 5 4 3 1 6 7. Yeah, we're good. I think we're good. Yeah. Okay. So how are we doing, everybody? As always, before we get started, this is not legal advice. We do not offer legal advice. If you're looking for legal advice, please reach out to your licensed local attorney. This is for entertainment and educational purposes only. Um, Diving into some case law tonight, and I'll probably start doing this after every little read through that we go through to give a better deep dive. I don't think we'll do two parts of this, but we might. Um, because I really want to make sure that we get the details because a lot of this is not, it's all relevant. Um, Especially if you're someone that's looking to, like, assert your own rights as opposed to turning them over, as we've looked into the etymology of that before. Um, uh, on a sidebar off that, actually, in our bio, if you're looking to, if you, for whatever reason, if you're looking to learn more about the legal system, um, and the procedures that go along with it, not so much public versus private, but understanding how to operate in a particular capacity in the legal system. What you can do is you can go to our YouTube bio in our description. If you copy that link, howtowinIncourt.com backslash with our code TS, I think it's 0028 or something like that. It'll take you to probably the best compiled legal um, course work that you can take in the entire world. Took it myself, expedited the process of learning the legal system, gave me a further understanding um, how to assert rights uh, in court with paperwork, speaking motions, writing motions, et cetera, et cetera. So if you're looking for something to buffer your understanding of the system and how to operate within the system, if for some unforsaken reason you do get dragged into court, please check out that description and that link in our bio, um, and have at it because it's chock full of information all the way from motions, hearings, to appeals, to how to present paperwork, templates of the sort, and everything. So I just wanted to let that be known because that's a really good resource. Definitely changed the game. So with that being said, we're gonna go ahead and hop into this Hale versus Henkel. So there's a lot of Hale versus Henkel talk that goes on, and we might not get to the good nitty gritty part tonight. We may not. It just depends on what we're feeling. I want to make sure I take my time with this, read through it slow, and go through the bits and pieces of it. But basically, this this was at a time where judges and courts were not so discreet on explaining the difference between public and private. We talked about that all throughout our Weiss's Concise Trustee Handbook read through. The difference between public and private. That's why we're going to this next, because when you understand that difference, it makes everything clear. If you can understand the difference between public and private, and you understand the gist of and the core of jurisdiction, you're going to be able to navigate the appropriate way when you need to navigate the appropriate way, if that makes sense. So with that being said, let's go ahead and hop into it. Obviously, if we come across some words that we don't know, um, we're gonna go ahead and look those up in the Black's Law Dictionary. We're gonna take our time with this. I have not read this case all the way through, actually, just as a full giving you guys full disclosure. And I've read this case before, but only because like so much of it doesn't have. It's relevant, but it's not relevant to what we're specifically talking about. Um, but I wanted to go through the entire thing so that people have a good understanding of people have a good understanding of anything in regards to being subpoenaed, their Fourth Amendment rights, their Fifth Amendment rights, public versus private, corporate versus like person versus individual, like yada yada yada. So, um, you know what? We're gonna start with the syllabus. Let's go ahead and get started. Should I zoom in? Let's go ahead and zoom in because we can. Boom. Look at that. Oh, that's a little big, isn't it? Okay, let's do it. Under the practice in this country, the examination of witnesses by a federal grand jury need not be preceded by a presentment or formal indictment, but the grand jury may proceed either upon their own knowledge or upon examination of witnesses to inquire whether a crime cognizable by the court, recognizable essentially, has been committed, and if so, they may indict upon such evidence. In summoning witnesses, it is sufficient to apprise them of the names of the parties with respect to whom they will be called to testify without indicating the nature of the charge against them or laying a basis by a formal indictment. Just want to go through these words because these you'll see these words in the UCC as well. In criminal practice, the written notice taken by a grand jury of any offense, basically your notice of suit. In a civil case, it's called a presentment as well, but it's a little bit different. From their own knowledge or observation without any bill of indictment laid before them at the suit of the government. A presentment is an informal statement in writing by the grand jury representing to the court that a public offense has been committed with which is triable in the county, and that there is reasonable ground for believing that a particular individual named or described therein has committed it. So basically they think you did it, and they're serving you to come to court. Um, when we talk about a presentment in terms of commerce, it's talking about something completely different. So I wanted to make sure I covered that because that can be a little bit confusing if you're not careful. Um, let's see. So under this, basically, let me keep going. I'm gonna keep going before I sum anything up. The examination of a witness before a grand jury is a proceeding within the meaning of the proviso to the General Appropriation Act of 1903 that no person shall be prosecuted on anything which he may testify in any proceeding under the antitrust law. The word should receive as wide a construction as is necessary to protect the witness in his disclosure. Sorry, hold on. And this ties into the Fourth and Fifth Amendments, which is what it's actually saying it right here. So let me not get ahead of myself. The interdiction of the Fifth Amendment operates only where a witness is asked to incriminate himself and does not apply if the criminality is taken away. Basically saying, oh, I'm going to plead the Fifth and not incriminate myself. But if there is immunity that is granted through, whether it be through the Constitution or through some type of code or whatever, then you cannot plead the Fifth, so to speak, because now there's no consequences to incriminate yourself. Now, I'm not sure if that applies to, like, so let's say someone gets convicted and they get a not guilty against them, but then they have to testify regarding the same thing in a different suit under different circumstances. Could they plead the Fifth if that first suit goes to the Court of Appeals? That's a great question. I think they could, but I have to look at the precedent what the courts say, because if it's in the appeals, then he could still incriminate himself, because if that first suit is appealed, now he just basically put on the record that, yeah, I did it. I had the glove fit, no acquit. You know what I mean? Like, so it's one of those things where you got to be mindful of, yeah, they might tell you to do that, and as you'll see in this case, Hale, he basically was like, no, I don't care if you're telling me I don't care if you're telling me I'm immune. I'm not speaking. I'm not producing anything for you. Um The law takes no account of the practical difficulty which a party may have in procuring his testimony. Basically, they don't care if it's hard for you to produce documents or produce evidence or produce your own testimony if they subpoena you 2 days ahead of time or 5 days ahead of time, because it talks about this in the case. A witness can federal grand jury in face of a federal statute granting immunity from prosecution as to matters sworn to, because the immunity does not extend to prosecutions in a state court. That's a that stinks. But then again, you got to understand how the jurisdictions work. But essentially, like, he can't refuse to testify, because he's granted immunity in the federal jurisdiction, but at the state level, he's not. I mean, you got to notice, like, the federal and state don't necessarily interact too much. There's certain circumstances which they do interact, but for them, what people don't understand is you have the United States of America, and then you have the several states of the republic. So when we talk about the United States of America, we're talking about the private land republic, the private side, and underneath them are the several states, the republic, the Ohio Republic, the Massachusetts Republic, that's a Commonwealth, but you guys get what I'm saying. The Indiana Republic, the Michigan Republic, the California Republic. These things are important to know because on that side, that is the private side, whereas opposed to uh, the United States corporation. I want to pull this up because people just think this is some fake stuff, and it's not. It's a real thing. It's number 15, I do believe, or 12 or 15. Yeah, United States means a federal corporation. Instrumentality of the United States. An agency, department, commission, board, or other entity of the United States. I'll tell you, it's a corporation. They're telling you right there. You can be mad. You can say it's a conspiracy all you want. I don't like that word. I don't like conspiracies in general, but they're telling you what it is. They want to do business. And it's not necessarily a horrible thing. So keep going. So what I was saying, so like there's the United States of America and the state republics underneath that. You have the United States Corporation and the state corporations underneath that. So then you have the state of Mississippi, the state of Texas, the state of Arkansas. Those are corporations. Anytime it says state of, city of, county of, those are corporate entities that are operating out of the landmass. That's where it becomes confusing. You just have to remember there's basically two of everything. There's an inverse, essentially. And the reason why that's what's going back to my point where they're not intertwining. The federal is leaving them to be because they in a sense, especially on the public side, they can gain an interest when they want to, but they don't want to because they're trying to leave the guise of one of the reasons is they leave the guys. It's written in the code a little bit, but they leave they're trying to present the guise of, oh, it's truly so where I'm looking for free democracy, capitalism, all that stuff. We don't have an interest, when in reality they do, and it talks about how the state, or really Congress, if they want to, they can gain an interest in the affairs of public entities because those public entities were formed through the creation of the codes, which are derived from Congress. Basically, it's that Congress is the great grandfather. You know. Keeping on. In granting immunity, the only danger to be guarded against is one within the same jurisdiction. Yeah, so under the same sovereignty. So remember how I said United States of America Republic and the sorry, Tennessee State Republic or the Arkansas State Republic. Those are the ones you have guards for. But if I want to go from, like, I don't know, Like, trying to think of a good example. I want to go from like the state of the Oklahoma up to like I'm being tried in the state of federally, and I'm refusing to testify to basically say I'm pleading the fifth, but that's not gonna work because I'm saying the reason I'm pleading the fifth is because I want to protect myself if this case or something regarding this case comes back to Oklahoma, but you can't do that because that case is it's only in the jurisdiction that it's currently in. So tough beans. You better find a way another way around it other than pleading the fifth. Um, this is why you don't do bad things, guys. So you don't get yourself in situations like this. The benefits of the Fifth Amendment are exclusively for a witness compelled to testify against himself in a criminal case, and he cannot set them up on behalf of any other person or individual, or, or of a corporation of which he is an officer or employee. Okay, we're done with the opinions. Are we gonna keep going? Are we gonna let's see the appellant? You know what? Let's just read. Let's just read. I'm looking at what I want to skip through and what I don't want to skip through, but I'm not gonna do that right now. A witness who cannot avail himself of the Fifth Amendment as to oral testimony because of a statute granting him immunity from prosecution cannot set it up against the production of books and papers, as the same statute would equally grant him immunity in respect to matters proved thereby. I'll read that again. A witness who cannot avail himself of the Fifth Amendment as to oral testimony because of a statute granting him immunity from prosecution cannot set it up as against the production of books and papers, as the same statute will equally grant him immunity in respect to matters proved thereby. That one's a little confusing to me, I'll be honest with you, because we know public and private don't mix, and statutes have nothing to do with the Constitution. They do, but they don't. It just depends on what if you're talking about a true U.S. citizen as opposed to someone that is a private citizen, because those two are not the same. They're not the same at all. The U.S. citizen is a public citizen. The private citizen is a private citizen. Um, which it talks about this later, but just basically talking about like he can't use that fifth. You can't use the Fifth Amendment to basically say, "Oh, well, I'm not going to produce my papers," um, because he's already getting immunity. But you'll see the reason that Hale gives later. Um, sorry, I'm being a dead horse here, but let's continue. The search and seizure clause of the Fourth Amendment was not intended to interfere with the power of the courts to compel production upon a trial of documentary evidence through a subpoena ducis tecum. Deuces. Deuces. Now we gotta throw them deuces up. I'm doing my deuces up. Deuces. Deuces. That was a banger back in the day, wasn't it? The name of certain species of writs, or which the subpoena ducis tecum is the most usual, requiring a party who is summoned to appear in court to bring with him some document, piece of evidence, or other thing to be used or inspected by a court. So basically, a normal subpoena. Um, while an individual may lawfully refuse to answer incriminating questions unless protected by immunity statute, a corporation is a creature of the state, and there is a reserved right in the legislature to investigate its contracts and and find out whether it has exceeded its powers. Okay, I'm going too far into this overview. Are we gonna read it now or what? Okay. Okay. Where are we? Yeah. Well, in the okay, so going back to where where it was basically saying like this corporation can't like I was saying earlier, the corporation can't refuse, nor can the officer of a corporation technically refuse because you basically put yourself into the public because it's a creature of the state. When we talk about the state, we're talking about the corporate state, not the republic. The republic is the private, the landmass. The public, the state corporation is the public. I know it sounds weird because republic is private, but that just got make sure you gotta make that understanding, make that connection. There's a reason why they have interest. They created it. It's the doctrine of essentially parents patria. It's one of the most powerful, crazy doctrines that nobody knows. Let's look at that one. I know we're going on tangents. Sorry. I'll probably do a part two. Parents betray. No, no, there we are. Is Latin for parent of the country or household. Sorry, homeland. Goodness gracious. Under parents betray, a state or court has a paternal and protective role over its citizens or others subject to its jurisdiction. The doctrines of parents betray is a doctrine under which a state has third party standing to bring a lawsuit on behalf of a citizen when the suit implicates a state's quasi sovereign interest for the well being of its citizens. The parents betray doctrine is also the doctrine in which all orphans, dependent children, and persons deemed incompetent are within the special protection and under the control of the state. We know what the word persons means, but let's look at incompetent. Because this is important to realize, like, before we even get into the nuts and yeah, we're gonna end up doing two parts of this. It's not a big deal. People gotta understand this stuff. Because I can rush through and read, and we can talk about private and public. Like, yeah, we know that, like, a little bit of that stuff, but this is the stuff that's really important to break it down. This says that a person is incapable, inefficient, and without the qualities needed to discharge their obligations and duties. Thank you. These are people who have their rights and safety protected and guarded by the courts. Oh, so you mean like you mean like you mean like what it says right here. So all orphans, all all dependent children. Here's the thing, you got to understand. You are incompetent until you hit the age 18 technically. You literally like you're not able to sign for certain things legally. It's not legally binding until you hit that age of majority. Um, I'm paraphrasing there. Don't hold that against me. But people gotta. This is probably one of the most. Oh my gosh, where's the other one? And loco, parentis. Ooh, fire. Oh come on, don't hide it. I was about to say. Is a Latin term in the place of a parent instead of a parent. The term refers to a common law doctrine, thought that was gone, obviously not, which denotes the legal responsibility of some person or organization to perform some of the functions of the responsibilities of a parent. The typical organization found to be in loco parentis is a school, which is deemed to have some of the responsibilities of a parent over its students. Additionally, siblings or grandparents who take on the role of raising their sibling or grandchild may also be found in loco parentis. So crazy when you send your kid off to public school, which all schools are public. All schools are public. Don't let anyone tell you otherwise. You're literally sending them off to be parented by someone else. This is why they're able to get away with certain things that they get away with in the school system with the disgusting trends that you're seeing nowadays without saying anything um, to get flagged. I want to see it. Let's see if they're gonna give me the full def. They probably won't. But just you got when it comes down to anything, there you are. There's that. When it comes down to anything, like break the word down into its syllables. Like literally break it down into its syllables and you will get answers. Pair, rent. Pair, rent. Pair, rent. A pair that rents. A pair that rents. A pair that rents. Because you don't own your child. Who owns your child? Who owns your child? All that are deemed incompetent are under the control of the state. Why are they under control of the state? Because you gave them up. You have an adhesion contract, but that's a whole nother topic of discussion. Whole nother topic. Whole nother topic. Okay, continuing. Sorry. There is a clear distinction between an individual and a corporation, and the latter, being a creature of the state, has not the constitutional right to refuse to submit its books and papers for an examination at the suit of the state. If an officer of a corporation which is charged with a criminal violation of a statute cannot plead the criminality of the corporation as a refusal to produce its books. Corporation is basically a body without a soul. Corpus, corporation, expiration, corpus expiration, corporation. That's where that word is. Break the words down. That's why you have to renew your license, your business license every single year. Corporation, it expires. But what you got to understand, also, they're telling you right here. This is so big. It's right here. A creature of the state, any creature of the state, regardless if it's a corporation or not, does not have constitutional rights. They don't have any constitutional rights. That is huge to understand. So, when we talk about a creature of the state, let's see if we type that in. If it'll give us anything. I don't know if it will. Creature. It might. Creature of the state. No. Let's look at Ensligus because that might Ensligus. That might give us something. Ah, man. I want to show people this one. Congressional record. Yeah, we're definitely gonna do two parts. It's okay. 1967. So I want to get a foundation of this. Get a foundation. I wasn't planning on doing it like this, but here we are. No. Come on, bro. Just give it to me straight. Give into. Come on. You guys are going to play around. Oh, man. They literally say it in the congressional record of 1967. Here it is. It's on Fam Guardian. It's right there, actually. They literally had. It's right there. Now, I wouldn't go as far and say never use the term citizen, but I do understand what they're saying because there are two types of citizens that people don't realize. I just want to show you guys one thing from this 1967. So, there's a couple. No. No, that's not the one. Come on. Civilly entity 1967. Just looking for. Oh, there we are. That's the good stuff. Congressional record, June 13, 1967. This just to let you know I ain't pulling your leg here. This is in the United States Bankruptcy Court District of South Carolina. Alleged debtor, yada yada yada. But I just want to show you guys that. June 13th, 1967. A citizen of the United States is a civilly dead entity operating as a co-trustee and co-beneficiary of the public charitable trust, the private constructive Sesticade Trust of the United States Incorporation, under the 14th Amendment, which upholds the debt of the United States of America and U.S. Inc. in Section 4. So, if that is a civilly dead entity, let's keep going back to it. I'm just trying to tie the dots together here, and then we'll keep going. These are foundational principles that have to be understood. I just want the normal definition of corporation, my friend. I already broke it down, but I want to see if they'll give it to us. If you don't, Black's Law 4th edition. It's hard to find, but get you one. I got excited because I thought I found one on Amazon for a good deal, and it came in the mail, and then it was only letters H through whatever. I was heartbroken. You guys are not gonna play nice tonight, I see. Incorporation, the act or process of forming or creating a corporation, the formation of a legal or political body with the quality of perpetual existence and succession, unless limited by the act. See, corporation, bro. They're not gonna give me that. They give me everything but corporation. This is the last. Oh, perfect. Yes. An artificial person or legal entity created by or under the authority of the laws of a state or nation, composed, in some rare instances, of a single person and his successors, being the incumbents of a particular altis, but ordinarily consisting of an association of numerous of individuals who subsist as a body politic under a special denomination, which is regarded in law as having a personality and existence distinct from that of its several members, and which is, by the same authority, vested with the capacity of continuous succession, irrespective of changes in its membership, either in perpetuity or for a limited term of years, and of acting as a unit or single individual in matters relating to the common purpose of the association within the scope of the powers and authorities conferred upon such bodies by law. Long story short, it's an artificial person. It's not a real person. Creature of the state. Being a creature of the state. Civilly dead entity. It's the same thing. It's the same exact thing. So that's telling you right there the U.S. citizen is a civilly dead entity operating. It's a corporation, but it's a public trust too, because when it fits you to take the benefits to put you in the jurisdiction, they name you beneficiary. That's why whenever you go to fill out an IRS form, this is not legal or financial advice whatsoever. This is entertainment and educational purposes only. But when you go and fill out an IRS form, that's why they ask the name of the beneficial owner, because they're placing you underneath their jurisdiction, because they want you to be the beneficiary. Because when you accept benefits and privileges, you are underneath them. That you're telling them that you need them. You're telling them that. But when they want to drag you into court, they flip the script from right underneath your they pull the rug from right underneath your feet, and you go from beneficiary to trustee. Because why? As we talked about in our read through of Weiss's Concise Trustee Handbook, trustees have the liability. Beneficiaries don't. Trustees do. So it's important to realize that. Franchises of a corporation chartered by a state are, so far as they involve questions of interstate commerce, exercised in subordination to the power of Congress to regulate such commerce. And while Congress may not have general visitorial power over state corporations, its powers and vindication of its own laws are the same as if the corporation had been created by an act of Congress. Just like I said earlier, it's the grandfather effect. No, Congress didn't directly create it, but it was created because Congress created what they created. If that makes sense. Sorry, I know that was a little jumbled, but um, yeah. I gotta go. Let me go. Let me see if I can find it. And this is why the reason why this is important. A good buddy of mine just posted this the other day. This is like telling you, man. People need to start waking up and really assert themselves. There are new laws now. Funny enough, starting January 21st. Sorry, starting January 1st, 2024, all LLCs, corporations, S corps, C corps, etc., because of the Corporate Transparency Act, the CTA, will have to report and disclose who the owners are to the United States Treasury Financial Crimes Enforcement Network, or face fines up to 2 years in prison if you do not comply with the new reporting requirements. Same penalties can be put on your lawyer, your accountant, registered agent, etc. So it basically they're telling you like that alone. If you don't believe what I'm saying from what Hale and Henkel is explaining, the fact that they're passing more laws to make you that now register with the Treasury is telling you that they're putting the squeeze on. Like this is a big deal, guys. This is a very big deal. Like very big. I'll pull it up real quick. Let me see. It's on I think it's on, let me see, Corporate Transparency Act, and then we'll move on. Here it is. No. No. Where is the article that I wanted? It's from Law Inc., I think. They're putting the squeeze on small businesses. And what is considered a historic legislative change, the Corporate Transparency Act (CTA) requires almost all new and existing corporations and LLCs to disclose ownership information directly to the U.S. Department of the Treasury Financial Crimes Enforcement Network starting January 2024. The purpose of the CTA is to enhance U.S. national security by preventing misuse of corporations and LLCs for money laundering, cybercrime, fraud, tax evasion, which is, if you're doing any type of tax evasion, this is not legal or financial advice whatsoever, but you are a dummy. They're always going to come and get theirs. You are not slick. Everyone just like thinks, oh, I can get over on the government. I'm not gonna pay my taxes. I'm gonna evade my taxes. Go ahead. They might not come for you this year. They might not come for you next year. But sooner or later, they're going to be breathing down your neck so hard, you're going to feel condensation dripping down your spine, and you're going to get chills when you're sitting in freaking jail because you decided that you want to take PPP loans and these extra credits without thinking you're going to have to pay this stuff back. And then we'll be sitting here laughing at you because we told you to go get a trust to mitigate your tax liability legally, but you wanted to play the stupid game. Okay, let me know how that works out for you. Because you can run a business out of a trust very easily. This is not legal advice. Like, look at these fines. If you don't do it, $500 a day, up to $10,000 for willful noncompliance, $250,000 for misuse of ownership information, criminal penalties. Look at this. Look at look at this. Somebody come and look at this. Look at this stuff, man. It's funny because some few people I know were looking at starting up a business, and we were just like, okay, well, they just made the decision easy, not using an LLC and S corp. Beneficial ownership. Oh man. Anyways, continuing. This is how far into this are we? 'Cause I might cut this off and then go go into this just reading this tomorrow, or it's not tomorrow, Saturday, because this is the meat and the bones. Yeah, this is the meat and the bones that we're starting to get into. Because obviously we're not getting through all that tonight. And I know how people study nowadays. They don't. Yeah, here we go. This is all the meat and bones. People can't watch videos for longer than 30 to 45 minutes. So I'm gonna rename this part one actually. We might do part two, maybe part three, 3 parts. But I wanted to spend a lot of time talking about the foundation of like public and private and looking at some keywords before we jumped in. It's funny because I was actually funny enough and I was gonna just jump in tonight and just start reading. I'm like, that doesn't serve anyone. That don't even serve me. And I know public and private pretty dang well, like I think I do. But you can always learn better. But if I'm sitting here and like people are looking to learn this information and I don't break it down for them into public versus private and put it into simple terms, then this is a waste of time. Um, so hopefully I made that a little bit clear because now as we read through the meat and the potatoes of the of this case, it's gonna make things make a lot more sense. And obviously it's gonna take us a minute when we start to dive into that part. Um, to get to the part where it's talking about private citizens. But even then, I've seen a few people do some overviews of Hale versus Henkel, and they just skip to the private corporations and to the private citizen and the public corporations, and they just go over that part and that's it. But I think it would be very beneficial, not just for myself. I know it would be very beneficial for myself. It's going to give me more understanding of the system, but also beneficial for you all out there to be able to see a breakdown, looking at the word and the etymology of words and understanding like what our system, how it's operating, and how you can get essentially like start to brainstorm within yourself of okay, well, how do I protect myself? How do I operate with knowing this information? Because information is great, but if you're getting a whole bunch of rabbit hole information and anything that's not giving you tools or ideas on how to act on certain things, it is a waste of time. Whether it's the Bible, whether it's anything, it could be anything. If you can't act on it, it's a waste. It's a waste because we have to be able to affirm what we know and what we believe by putting it into work, putting it into action. Because we know faith without works is dead. Um, I'll read this last little part and then we get started. Or sorry, then we'll cut it off for the night. Um, a corporation is but an association of individuals with a distinct name. I read this already, didn't I? No, I didn't read this. Franchises of a corporation chartered by a state are, so far as they involve question. No, I did that one. I didn't do this one. Okay. A corporation is but an association of individuals with a distinct name and legal entity, and in organizing itself as a collective body, it waives no appropriate constitutional immunities. Appropriate. Notice how it says appropriate constitutional immunities. The ones that are appropriate for the corporation, because not all constitutional immunities apply for corporations, and that's why you have to. That's why it's important to make these little details when they pop up. Um, and although it cannot refuse to produce its books and papers, it is entitled to immunity under the Fourth Amendment against unreasonable searches and seizures, where an examination of its books is not authorized by an act of Congress. Basically saying they don't have to produce books or papers, and they can refuse. Um, sorry, not it can't refuse, but it's entitled to basically, if something were to come up where they were seen for a crime through the reading and reviewing of these books and papers and whatever, um, if there was a code in Congress that basically says you are immune because of such and such through this and that because we search your books or whatever it may be, it could be worded something differently. They have access to that through the Fourth Amendment, but only if Congress made an act, which is very, very important to make that distinction too. That just clicked to me because I'll read it again. And where an examination of its books is not authorized by an act of Congress, a subpoena ducis tecum. I'm wondering if I'm saying that. I think I'm saying that right. Tecum, requiring the production of practically all its books and papers is as indefensible as a search warrant would be if couched in similar terms. Against unreasonable searches and seizures. So, what I'm getting from this, where an examination of its books is not authorized by an act of Congress. So, the link here, so obviously it says right here that it is entitled to immunity under the Fourth Amendment, but and they can't refuse to produce its books. But if Congress hasn't passed an act that allows the examination of these books and these papers and these records, like it's basically like you can't, like, the reason why Congress has to do that is because Congress is essentially their, like, it's the Luke I am your father type of thing. Like Luke would never got his powers if it weren't for Anakin. You know what I mean? It's the same exact thing. It's the corporations are derivatives of the Congress. I know I'm bouncing around here. I'm trying to make sure that I'm saying this in the most simple, watered down way that I can. Um, but that's as that's as simple as I can keep it for right now. Um, I'll come back to that one because I know I have some more I want to say on that. So give me a little bit to marinate on that. I'll probably come back to that in part two. Although the subpoena may be too broad in its requisition, where the witness has refused to answer any question or to produce any books or papers, this objection would not go to the validity of the order committing him for contempt, which, yeah, they can't refuse. Because you're underneath the jurisdiction of the court. They're telling you as a corporation And as an officer of that corporation, you're no longer a private c- citizen, technically. That's why this Hale versus Hinkle case is so weird. Um, Once you decide to sit in that public seat, you're in the public. Um, and so you can't sit there and say, oh, I'm refusing. But if you refuse, like, yeah, you might be, let's say you refuse and you protect. Okay, well, now they're going to hit you with contempt charge. Um, and obviously, they can throw you in jail for contempt. They can fine you. They can do whatever they want depending on the state that you're in. So, um, I'm trying to think if there's anything I want to hit on, like public versus private, before I shut this part one down. Um, or an examination of his books. Um, this is a good synopsis, but I want to read into it. This obviously was from a final order in the circuit court. Um, okay. We'll leave it at that for now. I think we got a good foundation going. Um, Again, if you have any questions, please feel free to reach out. Like, subscribe, share. Follow us on Instagram, govern.yourself.accordingly. Look in our bio on our YouTube if you're looking to learn more about how to, like, things like this. The course, the jurisdictionary course, talks about this. And yes, it is a referral code. We do make off of that, but it's also to help you guys, because I'm telling you, the price of this course for what it's actually worth, they could easily sell this for 5 times the amount and it would still fly the way that it does, because it's that good. I wouldn't just say that. The course is that good. It does everything, especially if you're like a note taker like I am. I take copious notes because I want to understand and remember everything. And if you're taking notes, key tip: do not take notes in black ink. Take them in blue ink. Take them in red ink. Take them in a colored ink. Your brain's gonna remember it a lot easier than opposed to just black ink. But anytime you're doing anything like reviewing anything, you should be like your mind, and you're gonna be able to remember it and put it into practice a lot easier if you take notes as opposed to if you're just listening to it. Like, I'm glad there are people out here that will listen to this, but at the end of the day, you got to get to the point where you are taking notes on some things, because you are going to forget those things, and you want to make sure that you're able to apply those. So, um, with that being said, um, we're gonna shut it down. We're gonna do part two here in the next couple of days, because I didn't think I was gonna start with a foundation, but now we're starting with a foundation. So, um, hopefully the foundation will help as we start to get into like the start, the top, the bottom, and it should only be 1 or 2 parts. Sorry, 2 or 3 parts. So